Hello, it's Philip Taylor speaking from Richmond Green Chambers, and today I'm looking at a book from Oxford University Press. This book is called Commencement of Insolvency Proceedings. It's this blue book here. Now, you'd think that's a very sort of wide title for a book. It's actually part of the Oxford International and Comparative Insolvency Law series, and this is the book launching it. The book itself is edited by Faber, Niels Vermunt, Jason Kilborn and Tomas Richter. We've given it a title on the web and in the journals of A Perspective on Domestic Insolvency from 20 countries, including otherwise inaccessible materials in English. And what we say is that it's ideal for international insolvency practitioners because it's the first of this new series, and it's a pioneering series from OUP, on the International and Comparative Insolvency Law series. And the aim of the series, as the publishers have aptly put it, is to provide practitioners with a working background on the specific features of a foreign legal system when advising clients and engaging foreign counsel. And there are 20 legal systems examined. Now we'll have a look at them because this book is important in the longer term, because we will eventually have to start getting, because of the nature of our global society, getting much more involved in understanding how other systems operate. The book's a heavy one. It's nearly 900 pages long, 850 odd. The book itself has the standard footnotes at the bottom, and you've got paragraph numbering at the side to find what you're looking for. There's a very substantial index, which you can see there right at the back. And what you've got is you've got the actual bibliography for the various chapters, again, at the back of the work itself. And the work, if I can show you the front of it, sets out, there's a very useful foreword to give you an idea of what it's about. And then there's a various prefaces from the series editor and the individual editors. Then you've got the general outline of the national reports that are produced, and you've then got the table of contents, and you can see the table of contents starting off in there with the Australian system. There are a total of number of reports of 20 in total, and that is the summary. You can see all of them listed. Obviously England is mentioned, and there's the second part of it. It's a heavy book, and it's a very good one. Do read our review in some detail. We are talking here where the two editors, the main editors, Faber and Niels Vermunt, who are also the series editors, express the view that this is the foundation of any future harmonisation of insolvency law. Obviously they're looking very much at how we're going to look at this issue globally. There are a whole range of particular points which I think are worth bearing in mind. The research, I think, in many areas is better left to comparative legal sociologists, with some of the particular areas they look at, such as the troubled waters of judicial independence, and also issues, for instance, such as corruption, which do occur in this particular area of law. It's, I think, distinguished as a book by its usability as well as its readability, and the copiously footnoted works that are actually in detail at the bottom of almost every page is a mine of scholastic information. There's a good table of contents, so if you're looking for stuff which you can't find in the detailed index at the back, it certainly will be in the contents. We feel that this book is very well suited to both practitioners and academics involved in global business, and they do very well, in our view, to add it to their professional libraries. We would like to wish certainly the new series the best of success, and thank everybody involved in its production. Thank you very much. Bye-bye.